My name is Patrick Kennedy. I'm JD, class of 1993, and president of the VLSAA Alumni Association. I'd like to welcome you to the VLS Alumni Webinar Series, which is being presented by the VLSAA today. Also on the call and presentation today with us are three VLS staff members. Brooke Herndon is the Vice President for Alumni Relations and Development. Crystal Brownell is the Director of Alumni Relations, and Lauren Close is VLS's Alumni Communications Manager. They've assisted us with the event today. As graduates of Vermont Law School, all alumni are part of the VLSAA. And part of the role of the VLSAA is to connect fellow alumni to each other and to VLS. We stand strong together as swans at over 8,000 alumni, and we are pleased that you've decided to join us today. Before we get started, I'd like to review a few housekeeping tips with you that should help make this presentation go off smoothly. You should have seen the email with the link for today's event that we'd like to request that you rename yourself so that your fellow alumni can see who is on today's call. If you see my name, you'll see my full name and class year there. If you could include your first name and last name and maybe also your maiden name too, if you'd like, along with your class year, that would be great. You can easily do this by clicking on the three dots in the upper right-hand corner of your own tile, and then a drop-down box will appear. Use the option that says rename and hit OK. During today's call, we'd also like to request that you mute yourself when you're not speaking to ensure that we can hear Jared Carter, our presenter, without any distractions or background noise. Also, if you have any questions for our host, you can enter them in the chat feature, and we'll do our best to have Jared answer as many questions as we have time for at the end. Now I'd like to introduce Jared Carter, our speaker. But before that, there's one other item. Please also note that we're gonna value your feedback, and you'll be receiving a short post-event survey regarding today's event. We'd really appreciate it if you'd take the time to fill out the survey. It will only take a few minutes, so be on the lookout for that in your email after today's presentation. Now for Jared Carter, our presenter. Jared graduated from Vermont Law School in 2009, and during that time he received an Equal Justice Foundation Fellowship to litigate a constitutional challenge to the U.S. Treasury Department's regulations prohibiting travel to Cuba. A veteran attorney and advocate for social, legal, and environmental justice, Professor Carter spent a year as a law clerk to the justices at the Montana Supreme Court in 2009-2010. As an assistant professor of law, Professor Carter has taught a range of courses, including legal writing, climate and the law, environmental communications, advocacy and leadership, legal activism, appellate advocacy, First Amendment law, and natural resources law. An active member of the Vermont Bar, Jared also directs the Vermont Community Law Center, litigating constitutional and civil rights issues in state and federal court. Outside his legal work, Professor Carter is an avid outdoors person. He enjoys backpacking, canoeing, fly fishing in the warmer months, and cross-country skiing in the winter. Despite the fact that Vermont is landlocked, Jared also enjoys surfing and does so in the frigid waters of the New England coastline. So now I'd like to hand it over to Jared Carter for today's presentation. Thank you, Jared.
Great, thank you, Patrick. And thanks to all the folks in the alumni office for helping put this together. And most of all, thanks to all of you fellow alums out there who are joining right now. I will say on a note related to Patrick's wonderful introduction, when I was a student at Vermont Law School, there was actually a surfing club, believe it or not, even though we were way up in Vermont. I don't think it exists anymore, but an interesting side note. So I want to talk about today broadly themes relating to the pandemic, the Constitution, the rule of law, and where do we go from here? And the reason I want to talk about that is because I think both as a faculty member with my students and interacting with alums and generally people out there in the population across the country, I think there's a lot of fear and trepidation. And I think it's important to remember these basic principles stemming from the Constitution. And so I want to tell a story more than anything about these ideals of the rule of law, of democracy, of the Constitution through the lens of the pandemic. And so many of the principles we'll talk about today may be familiar to you. Maybe you practice in some of these areas. Maybe you haven't thought about the Constitution since Professor Teachout's 1L Constitution class, constitutional law class. But nonetheless, I think they're important topics to think about. And my hope is that through this theme of the rule of law, we can really end up in a hopeful place, because I think there's a lot of angst, a lot of anxiety out there in the world. And I think that the power of the law, the Constitution, the rule of law, democracy are all well springs for us to draw from. So thank you very much for being here to chat about all of those things. And as Patrick said, we'll have plenty of time at the end, hopefully, for question and answer after we sort of move through the discussion, if folks want to get more into the details of particular constitutional issues stemming from the pandemic. So I'm not sure where all of you are, but I'm here in Burlington, Vermont, where fall is in full effect. We've had our first snow. My snow tires are on. It's actually a kind of a nice New England late fall afternoon. And so I appreciate all of you coming to have this conversation right now, because perhaps where you are, the sun's shining, and here you are in front of another Zoom call talking about the Constitution and the rule of law. So as I said, it's fall. The leaves are have pretty much fallen off the trees. The days are getting shorter. It's getting darker, and we're in for another long New England winter, as I'm sure you all recall if you're not in Vermont or New England anymore. Cold days are coming. So it might seem odd to talk about regeneration and the power of the law in light of where we are in the calendar. It might not be the greatest stage to set, but I think it's an important place to start. Because yes, it's going to be a long and difficult winter, metaphorically and literally in Vermont. But I think that if we understand the rule of law and the power of the Constitution, we're in a place where the stage is set for one of the greatest comebacks in the history of humankind. And I think the rule of law, democracy, and the Constitution, at least in this country, are all going to play a fundamental role in that. So today I want to tell a story. I want to tell a story about where we've been as a country, constitutionally, democratically, the rule of law, because I don't think we can understand where we're going in this pandemic without understanding where we've been, right? They say failure to understand the past means you're likely to replicate the mistakes in the future. And there's a funny story that I've heard told in Vermont, and maybe you've all had experiences like this if you remember your days in South Royalton, of a tourist somewhere out there in the hinterlands of the Northeast Kingdom trying to find their way back to the Burlington airport to fly home. And the tourist stops at an old farm, and sort of a salt of the earth farmer comes out, looks the tourist up and down, and the tourist says, "Well, farmer, how do I get to the Burlington International Airport?" And the farmer sort of looks at them and says, "Well, I could tell you, but I wouldn't start here. I wouldn't start from here." And I don't know if that's a true story or not, but I think it's a good metaphor for this idea of, in order to understand where we can go with respect to the pandemic, we've got to understand where we've been and where we are. And so the story I want to tell is that, the story of where we've been, so we can understand where we're going as a country with respect to the rule of law, with respect to the Constitution, with respect to democracies. And truthfully, the story has elements of a tragedy. Like any great story, there's elements of a tragedy. There's trials, there's tribulations, there's false starts and setbacks. But in the end, I think it's a story that's one of progress, continual, albeit stuttering and sometimes bumbling along progress. But I think what we'll see when we look at this story, that in those moments of greatest trial, greatest tragedy, they have always been the birthplace of that progress. In other words, we need these challenges to our Constitution, these challenges to the principles of the rule of law and democracy in order to take steps forward. And the story starts, as you might imagine, with our founding. The story of the nation's creation, this idea of taking steps forward from places of hardship, but also taking a step back, 2 steps forward, 1 step back. And the story starts with the founding, our revolution. And you probably recollect, perhaps from constitutional law or maybe high school civics class, right? What was going on at the time of our revolution? We had an oppressive British crown, taxation without representation. We had colonists rise up against that quote unquote tyranny. We had the Declaration of Independence that all men are created equal. And ultimately, the Constitution and the Bill of Rights, those first 10 amendments that focus on the freedom of speech, the freedom of the press, of religion, of privacy, due process, all of those were part of a giant leap forward out of this, in many instances, violent revolution. So we took a tremendous leap forward from this place of hardship. Now, of course, we took 2 steps forward, 1 step back. So while we got the Bill of Rights, while we got these fundamental constitutional rights from the revolution, they enshrined, as you probably recall, slavery. And in large respect, many of those rights only applied to who? Propertied white men. And so 2 steps forward, 1 step back. 2 steps forward, 1 step back. But nonetheless, we moved forward from that place of crisis, from that revolution, what some would call actually a civil war. We moved forward. We made progress, even if haltingly so. Flash forward about 70 years. And it's interesting, these junctures in time, as I'm telling the story, if you do the math, they seem to fall about every 70 years or so. And so if you jump forward 70 years roughly, where do you end up? You end up at the Civil War. Another great time of upheaval, societal upheaval, secession, lack of fidelity to the constitutional order. Hundreds of thousands of people in the course of the war killed, injured. The Battle of Gettysburg, the Battle of Shiloh, the Wilderness. Tens of thousands of people who had their lives upturned or destroyed entirely. A president assassinated. So great tragedy, great upheaval, great chaos, great fear. But we got the 13th, 14th, and 15th Amendments to the United States Constitution, right? The 13th Amendment banning slavery, the 14th Amendment guaranteeing equal protection of the laws, the 15th Amendment guaranteeing the right to vote for folks who had previously been held as slaves. So we took a giant step forward from that crisis, from that tragedy. And yet, as with all of these little vignettes I've told so far, with those 2 steps forward, we took some steps backward, because remember, women were still denied the vote. There was no universal suffrage despite the 15th Amendment. And in many respects, those wonderful words on paper that did so much gave birth to the KKK and the Jim Crow South and complacent North. So out of this crucible of tragedy, we took giant leaps forward as a country, grounded in the Constitution, grounded in the rule of law. It was imperfect, of course. 2 steps forward, 1 step back. Flash forward another 70 years. I'm a lawyer, not a mathematician. Not sure if this is exact. But where do you end up? Somewhere around the Great Depression. Is that right? 50, 60, 70 years, somewhere in there. You end up at the Great Depression. Economic collapse, breadlines, Hoovervilles, family farms and families destroyed, the Dust Bowl, savings lost, famine, families destroyed. I mean, you can't get any worse in terms of chaos, upheaval, societal shifts. But we got a New Deal. We also got World War II, I suppose, and some would argue that's what led to the economy coming back after the Great Depression. But nonetheless, we got a New Deal. We got a social safety net from these tragedies of the Great Depression. We got public works projects that connected the country. We got financial reforms. We got Social Security. We got the Labor Relations Act and other laws meant to remedy the situations. So a tremendous step forward in many respects from this time of tragedy and chaos. But we also gave birth to what today we see as massive income inequality from this so-called New Deal, where today 1%, as I'm sure you've heard these statistics if you watched any of the presidential, particularly the primary debates, 1% of the population holds 40% of all wealth, where the top earners, 5% earn 5% of top earners earn 20% of the income in this country, where CEO pay is far greater than it was compared to the average worker 25 years ago. So we took a giant step forward with the New Deal, but as with all of these, it led to steps back. Tragedy, chaos allowed us to move forward, however imperfectly. So again, do the math, 1930, 40s, 70, 80 years forward, and here we are where we have a pandemic. I think we topped in this country, 11 million cases recently. Nearly 300,000 people have lost their lives. Certainly massive economic upheaval. I was in the Burlington airport last night, and of the 2 flights coming in the evening, a total of 6 people got off each airplane. So I think you can see the economic impacts there, not to mention folks who don't have the financial wherewithal or ability to fly on an airplane, the impacts that this has had on their livelihoods and their families. And then the racial imbalance of the pandemic. I saw some data the other day that said that Native Americans, African Americans, and Latinos are 4 times more likely to end up in hospitals with COVID-19 than Caucasian counterparts. So we're at another trying juncture, roughly 70 or 80 years since the last one. But just as with all of these constitutional catastrophes, these challenges to the rule of law that we've faced, I think there's an opportunity here to build the country back in a better and more equitable manner, just as we've done every single time. And so I want to think about, how does the rule of law fit into this? How does the Constitution fit into this? What the hell does the rule of law and the Constitution have to do with this story? Well, I think first it's important, as with any legal practitioner, to define the terms of the debate, define the terms that we're dealing with. So what is the rule of law? It's certainly something that I think is malleable, and there's many dictionary definitions, right? The idea that all people are subject to the law, that the government follows a particular set of rules and regulations in how it behaves. For me, in thinking about the rule of law and how it informs where we go with the pandemic and the Constitution, I like to think of the analogy of a house. And analogies were the weakest part of my LSAT test-taking skills. So I don't know if this is the best analogy out there. But when I think about the rule of law, I think about a house. I think about a structure. And it's a structure that everybody in this country lives in. So what are the key elements of a house? And what are the key elements of our system, of the rule of law? Well, obviously, every house has a foundation. And in my mediocre analogy, the Constitution is that foundation, right? The Constitution forms the foundation. It shapes the government, and it shapes the laws that hold up the rest of the building. It's got to be rock solid. It's got to be rock solid, just like a real foundation. It provides the shape. It's the bedrock rights and responsibilities. So that's the foundation, the Constitution, in this idea of the rule of law as a structure. Then you have the walls, the frame, the floors. That's, in my analogy, the state itself, right? The different branches of government, the checks and balances that are part of that, right? The idea that Congress shall make the laws under Article 1 of the Constitution. The executive shall execute the laws through the administrative state, the administrative agencies. Of course, they have to do that consistent with the intent of Congress, as you may recall from your administrative law classes, or maybe you practice this now. And then the courts, right? They play referee between the different branches to settle disputes, right? That's the frame. Those are the walls of the house, right? And perhaps the roof as well, in this analogy with respect to the rule of law. But what's missing? What's missing from that rule of law analogy? What holds all of that together? What holds the walls together? What holds the floors together? What holds the ceiling in place when we face headwinds? And I think it ultimately is fidelity to the Constitution, faith in the rule of law, and a belief in the strength of that structure. Truthfully, it's the people, right? Civil society. Now my analogy really gets sideways, but the people, civil society, are the nails, the screws, the glue that hold all of those pieces together that make up the rule of law in our country. They hold the whole thing up, despite its fragility. So how do they do that? How does all of this fit together? How does the rule of law function in light of the pandemic? And I'd take you back to illustrate, I think, this point to President Lincoln's first inaugural address. And he raised an interesting point that I've often thought about, and I think we struggle with as a country, but I think informs this idea of the rule of law and its fragility. And what Lincoln said was this, and I quote, in his first inaugural, he said, "The candid citizen must confess that if the policy of the government is to be fixed by decisions of the U.S. Supreme Court, the people will have ceased to be their own rulers, having resigned their government to the hands of that eminent tribunal." And I always thought that was an interesting quote coming from Lincoln, who we view in many respects as saving our constitutional form of government. And yet he's really challenging the U.S. Supreme Court and its authority. But in fact, what gives the U.S. Supreme Court its authority is the fact that we put our faith in it. We put our faith in that eminent tribunal. Think about it. Without our faith in that rule of law and in the Constitution that the U.S. Supreme Court employs, the candid citizen, to coin a phrase, must confess that the Supreme Court actually has absolutely no power to issue and enforce anything. It has no military force it can send out to force the president to do something, whether that's leave office or otherwise. It has no military or police force. President or Congress or a state, if they reject its ruling, there's really no practical way to enforce it. And so you might say, well, gosh, how is a system that is really not based on any actual enforcement mechanisms, how has it worked for 200 and some odd years? How has it gotten through a revolution, a civil war, a Great Depression? How the heck is it going to get through a pandemic? And the answer is, it only works because we all accept it and have faith in it. That's it. That's the rule of law, to my mind. Right? Many countries led by dictators have laws on the books that say you can't discriminate or you can't do this or you can't do that, and they regularly ignore them. It's not to say that we live in a utopia and that various administrations over the years haven't tried to ignore the dictates of the Supreme Court and the rule of law. But in the end, what sets, I think, our system apart is our collective faith in that idea of the rule of law and the Constitution. Not any specific rule or law that we might have adopted. This idea of the rule of law, I don't think, comes down from on high. No fidelity to it can be long imposed by force. Only by force of will can this idea of the rule of law endure. There's an interesting quote, and I know lawyers usually like to quote presidents and Congress people and senators and judges. But there's another quote I'd like to share that I think gets to this point of just how fragile the rule of law is. And that comes from the poet Walt Whitman, who, as it turned out, was a medic in the Civil War, or was assisted in the medical tents in the Civil War. And he asked the question rhetorically at the time about this idea of the rule of law and how do we protect it. And he asked the question rhetorically, quote, "Were you looking to be held together by the lawyers?" Sorry, lawyers. That was an aside. He didn't say sorry to the lawyers. Were you looking to be held together by the lawyers, or by an agreement on paper, or by arms? Nay, nor the world nor any living thing in it will so cohere. And I think he hits the nail on the head. We like to think that it's the Constitution that protects us, and in some ways it is. We like to think that a constitutional crisis cannot happen in the United States, even in the face of a pandemic, that it can't happen here because of the Constitution. Indeed, we're often taught that the founding fathers devised, and even in law school to a certain extent, devised this system of checks and balances and branches of government that makes it impossible for anything bad to happen, that makes it inevitable that it will endure indefinitely. However, I think in contemplating the fragilities of the constitutional system through the lens, say, of, as we've been talking, the US Supreme Court's really inability to physically enforce any of its decrees, I think we all need to confess that our constitutional rule of law, our constitutional order, hasn't and won't endure because of any one amendment or set of amendments. Rather, I think it endures because we believe it endures. And I recognize that maybe isn't satisfactory to lawyers who want things, we all want things written down on paper. And in some ways that makes it feel very fragile, right? Come on, it's just this idea that we believe in. That's what makes it so powerful. It almost feels like one of these cold New England late fall breezes could blow it away in a puff. It feels sometimes perhaps like it's illusory. And I know lawyers hate that. It should be written down somewhere. But I think it's that fragility. And this is why I'm optimistic about where we're at now and the Constitution and the rule of law. I think it's that fragility of the rule of law that makes it so powerful, right? It's diffuse. It's spread out amongst all of us. Right? We all hold it in our hands, hopefully in our hearts, in our minds. So that means it can't be taken away by any one person or any one branch of government or any one law or policy. It makes it all the more powerful because of that idea of strength in numbers. And I think it's worth thinking about that, right? Every year at Vermont Law School, we celebrate, in law schools across the country, celebrate Constitution Day. We did it virtually this September, but we celebrated it nonetheless. And while I imagine nobody breaks out the barbecues and, I don't know, the champagne and toasts at midnight, maybe we darn well should. Because despite the fact that we've made very few changes to that document in the 200 some odd years since it was created, it's arguably been the most important tool of change in our nation's history. It's constant, and yet it's been such a powerful tool for change. In fact, I can't think of one major, and I challenge anybody to do it, any one major social, political, environmental, civil rights movement in the history of our country that wasn't grounded in the Constitution. Right? The 19th Amendment in Lesser v. Garnett in 1922 guaranteed women the right to vote. Remember the story I told? Took a step forward. We achieved a key victory in the civil rights movement through cases like Brown versus Board of Education. And the basic idea that the Constitution said separate is not equal. A document that's been constant, but has been one of the strongest vehicles of change. In the efforts to achieve equality, regardless of sexual orientation, the Supreme Court's decision in cases like Obergefell and Bostock mandate that as a fundamental right. And even in the environmental movement, if you think about it, the vast public lands, the endangered species that populate them, in large part have been protected by decisions of the US Supreme Court, in which they've held that citizens and organizations have standing, grounded in the Constitution, to sue to protect those rights, sue to protect those places and those species. So while there may be false starts and setbacks, there's no question there's been this constant story of progress. And so while I, like probably many of you over the past months, fret when you watch the nightly news, you hear about the pandemic, right? The systemic racism, protests, seems chaotic. It can seem very overwhelming. And I fret about all of that when I see it. But I'm not scared, at least not yet, because of our collective faith in our Constitution and the rule of law. So even if at times that faith may be strained by the political whims of and currents of the day, I think as long as collectively we maintain that faith, and as lawyers, we have such an important role in doing that, I think as long as collectively we maintain that faith, it will always be there. It will always be there for future generations, truthfully, as a wellspring for the future. It always has gotten us through, and there's no reason, to my mind, why it can't continue to, as long as we believe in it, do that moving forward. It can be a wellspring for future generations to drink from. So with that, I'd be happy to take whatever questions folks have. I think it looks like we've got about 20 minutes to engage in a conversation. I'm more than happy to talk about some of these big, broad theoretical ideas that we've sort of chatted about. And I'm also happy to dig more into the details of sort of constitutional implications of actual policies on the ground and how the rule of law plays into that. But I thank you all for paying attention and joining the conversation. And with that, I'll turn it over to any questions that folks may have.
Jared, let me start with a question. With the second wave of COVID really burgeoning here all over the country, lots of states, including Vermont and Massachusetts and New England states, and probably states all around the country, have adopted travel moratoriums or bans that essentially are restricting the right of citizens to cross state lines other than for essential purposes, without either self-quarantining for 14 days or quarantining for a certain time period and producing a test. In some states like Massachusetts, there's a travel form that's required to be filled out, probably the same in Vermont. What's your view of these travel restrictions, the rule of law, and so the tension between the state's interest in public safety and public health and its right to infringe on what are ordinarily fundamental constitutional rights of citizens in the light of the pandemic versus the tension between the fundamental right to assembly, travel, et cetera?
Yeah, great question. And I think there's no doubt that the constitutional order that we are accustomed to in this country has completely shifted over the past 5 or 6 months, no matter what state you're in. Here in Vermont, the governor just announced that multi-household gatherings are prohibited even within the privacy of your own home. So if you wanted family to come visit you for Thanksgiving in the privacy of your own home, you couldn't do that. So I think these are legitimate questions and legitimate concerns. There's a case, and I'm going to get the pronunciation wrong, but there's a case from the early 1900s during the yellow fever pandemic that the U.S. Supreme Court decided that I think provides some answers. But the truth is we haven't had a pandemic really since the 1918 pandemic. And so there isn't much case law. But what this one particular case says, and it's Compagnie Française versus the Board of Health of the City of New Orleans. And what was going on there was a boat full of folks from primarily Italy who were attempting to land in New Orleans. And there were, I think, 408 folks on this boat. And they had all actually been confirmed to not have yellow fever, which was what was going around at the time. And yet the city of New Orleans said, you cannot land that boat here. And so I think you have a similar sort of situation where traditionally we think of it's the federal government's role to constitutionally deal with both interstate commerce, but certainly commerce coming from outside with international relations. And so that case went all the way up to the U.S. Supreme Court, and the U.S. Supreme Court actually said that it was within the city of New Orleans police powers not to allow that boat to enter New Orleans Harbor and dock, even though all of those people were healthy. So I think that the U.S. Supreme Court, when and if it faces a case dealing with some of these restrictions, I think if they're going to base it on that sort of analysis, and there's slim pickings in terms of case law, I think they're very likely to give states a lot of leeway with respect to public health measures.
Let me follow that up then. We've already, maybe a lot of people on the call or on the presentation Zoom have seen that Justice Alito gave a well-documented speech to the Federalist Society where he really hammered COVID restrictions with regard to religious gathering limits, and really hammered that the free exercise clause was being infringed in a draconian way during the COVID pandemic. Now we have Justice Barrett joining the court, who's well known to be a free exercise fan, a religious liberty proponent. What maybe a case involving religious rights might be viewed a little differently than the way you mentioned the public health case.
Yeah, and I think that's fair. I think the Supreme Court's obviously going to shift fairly dramatically. Elections matter in the end, and so we have a very different Supreme Court with Justice Ginsburg gone, certainly, than we did. So how are these likely to play out? Well, I think you're right. Justice Alito there's been a fair amount of press on Alito's talk, I think, to the Federalist Society about these free exercise situations and limits on the ability of folks to assemble in their place of worship. And I think that the Supreme Court has, again, not had much opportunity, thankfully, because we haven't had a pandemic, to really give us a lot of terrific directive. There is the case Jacobson v. Massachusetts, which again is an old case from the early 1900s, dealing with vaccination requirements. And in that case, so it's certainly not on point with respect to the First Amendment freedom of exercise. But I think the important rule that comes out of that Jacobson case is that the government, the states, are going to be given significant deference, and they talk about prohibiting state action only if it's arbitrary, oppressive, or unreasonable. And so I think that's the sort of analysis that the court would look at, and I'm sure Justice Alito would say it is unreasonable to say a church group can't get together, when it's okay to go into a casino in Las Vegas. And in fact, I think that's what he's said. So I don't think we necessarily need a new legal test. I think that there is precedent dealing with these sorts of issues with respect to public health out there. And obviously with the shifting court, it very well may be that they conclude that prohibiting religious gatherings while allowing, say, casinos to operate is arbitrary, is unreasonable, and thereby strike it down.
The Jacobson versus Mass case was raised by one of the by Caroline Eder in the chat area, asking if it applied. Sounds like it does apply to some degree.
Well, I don't think it's
there's a question.
It says it's not, it's not a free exercise case, but what we're really doing at this point, since we haven't had cases that are going to be on point with respect to international pandemics, we're sort of pulling from what's out there dealing with public health regulations and state actions with respect to public health. So vaccines is certainly one of those instances, and that's what the Supreme Court said. They could enforce a vaccine requirement as long as it wasn't arbitrary, unreasonable, or oppressive. So I guess if you can get 5 justices on the Supreme Court to agree that prohibiting church gatherings is unreasonable, oppressive, or arbitrary, then you've got your court case. But I think there aren't cases that are going to give us really good on point analysis here. And that's why
those cases, those cases in that case comes probably before the really ratcheting up of the constitutional tests that we all learned so well from our constitutional law classes at VLS. That is the strict scrutiny review, the middle tier review, and the rational basis review. But that arbitrary and not unreasonable test sounds more like rational basis to me. So to me, it sounds like when you're in a public health emergency situation, a pandemic, maybe greater leeway is given to the government to infringe on constitutional rights, at least for the short term. And so maybe something that would ordinarily be under a middle tier strict scrutiny might be reviewed under a rational basis.
I think that's entirely possible.
I'm not sure.
Yeah, I think that's entirely possible. And again, we're sort of reading the tea leaves because we don't have cases that are going to be directly on point. But the court has said pretty consistently that as a general principle, when it comes to issues of public health, it is within the state's purview. Now, that's certainly controversial, and I'm not suggesting that folks should agree with that, but that's what the court has historically done. And in other contexts, the same analysis is carried today, whether it's national security, borders, or otherwise. And in the area of public health, time and again, not in the context of a pandemic, but in other public health emergencies, the courts have said it's the states that primarily have the task of dealing with those. And they're going to be very unlikely, I think, again, for better or worse, to impinge on the purview of the medical experts and the local leaders that are enforcing these regulations, up to a point.
Here's a good question from Professor Robert Sand, and I'll just read it for the group in case you don't have the chat function open.
That'd be great.
Hold on a second. He appreciates your, Jared, your optimism and faith in the people. We are confronted with an extraordinary confluence of the pandemic and a possible flaunting of the rule of law. What happens if a president, probably meaning the president that's in office until January 20th, refuses to abide by decisions of the Supreme Court?
Well, as I think,
or maybe that's Biden.
Yeah, well, I mean, look, there's certainly instances where presidents have done that or attempted to do that in the past. So, and I think it's certainly a fair question in light of, again, politics aside, Trumps that the president has tweets that the president has put out about, whether he will leave or not. But I think in the end, as I said, the Supreme Court, if it were to rule that President Trump lost or that Biden lost, there is no way for them to, as we all know, actually enforce that, right? They don't have a mechanism. There's no Supreme Court police force. There's no Supreme Court military force to enforce their decrees. It only happens because we believe that it should be followed, even if we disagree with it. And so I think what has to happen in the end is that if the Supreme Court says something, the people need to be the executors of that decision. The people need to stand up. The leaders need to stand up. And I, in the end, believe that people will do that, as we've done for 200 and some odd years, even in the face of arguably more difficult circumstances. It won't be a linear path, right? It's never been. It's 2 steps forward, 1 step back. But I truly believe that.
There's an interesting question here in the chat from Hannah Brubach about how to deal with state and federal governments moving forward with rules and regulations restricting public activity when public participation is limited due to the pandemic, and essentially you can only really participate by internet or phone, or else you may breach assembly restrictions and other restrictions by the state. So there's a tension there. Do you have any comments on that?
Well, there's no doubt there's a tension there. So I think what you're seeing, at least in most states, to my knowledge, are generally short-term extensions of the emergency powers or the emergency situations. And that, I think, the courts are going to, again, if we look at the public health cases that have been up to the U.S. Supreme Court, they're typically going to defer to state regulations that are not arbitrary, unreasonable, or oppressive, and of limited term. But I do think there will come a time where, and I don't know when this time is, but this obviously can't go on indefinitely and forever. I don't think the people would accept that. As a result, I don't think the politicians we elect would accept that, and I don't think the courts would accept that. But I do think that for a time, and I don't think we're at that tipping point yet. Although I will say I've sensed in Vermont, as I said, with this new restriction on the ability of even within your own home to have your family visit, it sort of set up this odd, one could say, arbitrary situation where I could go have Thanksgiving dinner with my family from Maine at a restaurant in Burlington, but I couldn't have them in my house for Thanksgiving. And is that arbitrary? I think one could certainly make that argument. On the other hand, I think people are willing to do their part, but not forever, and neither will the courts allow it.
Patrick and Gerard, this is Joel Stroud. I apologize for verbally asking my question, but I have trouble typing. Is it all right if I verbally ask a question?
Absolutely. Jump in there, Joel.
Okay. My question relates to the effects that technology has now on COVID versus the 1918 influenza pandemic, and especially how it relates to employment rights. And I just noticed the other day that inmates were being paid $2 an hour to move dead bodies. And it just seems like the role of technology is either increasing or decreasing employment discrimination, or however you want to say it.
Yeah, I can't speak to that exact instance, Joel, but here's what I would say, and I think these are objective facts. If you look at whether it's the stock market or the bottom line, the companies in this economy that are doing quite well are obviously the tech companies, the Zooms, the Amazons, the Microsofts, as a general principle, because we've all turned to those, and at the expense of, and I think this is that economic catastrophe that I was describing earlier, at the expense of the local restaurant or the local store down the street. Amazon just announced it's going to open an Amazon pharmacy, and I won't. I mean, folks can agree or disagree on whether that's good, bad, or otherwise, but I think practically speaking, there are going to be massive economic implications of all of this. So I think you raise a good point.
All right, I appreciate it, and you're doing an excellent job there.
Hey, good to see you, Joel.
All right.
There's a question from Kate Frederick about mask mandates. And specifically, she's seen some discussion about mandating students to wear masks when off campus, for example, at some universities and colleges, maybe even VLS. And to attach mask wearing even off campus to student code of conduct violations and whatnot, and when there's a breach or a reported breach. She said she's seen many out on the green and sometimes on Microsoft Teams in class, all sitting outside together. If a student objected to such a mandate, would their constitutional rights be called into question?
Yeah, I think the mask question is a good one. Certainly, as a private institution, I don't think Vermont Law School would be subject to a constitutional claim because typically the Constitution applies to government actions. So I think private institutions, whether it's a school or a restaurant, could perhaps require that. I think when you're talking about state institutions, well, then yes, I suppose the Constitution does apply. But I think, again, the courts are going to be very unlikely, in my view, to step in and say that masks can't be required both on campus and off if they're having residential classes, because obviously if you go off campus and come back, if you haven't been safe, then that impacts the community. Again, I'm sure plenty of folks, perhaps disagree on mask use and sort of it's a political hot potato, but I don't think there's a constitutional moment there when it comes to requiring masks. In the same way, I mean, I'll give an example. You wouldn't bring a constitutional claim because the school or a business requires you to wear, you see the sign, no shirts, no shoes, no service. And so I think, at least at this stage, the courts are going to be pretty unlikely to find any problem with a mask requirement on constitutional grounds. Not saying it's politically popular,
but that's a private business versus public space. There's a question here from Malcolm Tram. Have many of these restrictions been challenged based on the Alito standard? In other words, I guess that would be it should be a strict scrutiny standard. He says Governor Murphy, I'm not sure which state.
Something.
Arbitrary and capricious, okay. Or arbitrary. And Governor Murphy admitted, I'm not sure what state that is, admittedly said he made decisions without determining the legality, and many of the restrictions were put in place in New York City appear to be pretty arbitrary. The mayor there said nobody could engage in protests of any sort in a particular Hasidic neighborhood locked down recently. Oh, Murphy's, New Jersey. Gotcha.
Okay.
So that again implicates the free exercise and religion. And there's also a thread, Jared, coming through the chats about that some of these restrictions appear tyrannical, and there's certainly a movement of some folks who feel that the virus is been overblown and it's not a legitimate cause for the nature of the restrictions that we're experiencing. Yeah.
So two things. I think to Malcolm's question, I think about sort of Justice Alito and this idea of if something is arbitrary, even in the context of public health or a pandemic, I think that is actually likely to be, some version of that is likely to be a test that the Supreme Court's going to apply in this context. And I would, again, turn back to that language from the Jacobson v. Massachusetts vaccine case from 1905, in which the Supreme Court said, if a particular regulation is found to be arbitrary or unreasonable, then it can be struck down even in the context of a public health regulation. So I think you're likely to see that play out, right? Is it unreasonable to allow, and I'll put this out as a question as opposed to an answer, is it unreasonable which is a classic law professor's move when he doesn't necessarily have the best answer. I'll put this out as a question. Is it unreasonable to allow a casino to operate, but not a church? And I think that's Justice Alito's point. And I think we're likely to see litigation around that. And the shifting court, I think it's entirely possible that they would find that it may very well be. What was the second thread, Patrick?
It just mentioned a particular lockdown of a Hasidic neighborhood. I think it was in Brooklyn or in New York City. And particularly targeted, I think the question really goes to a more targeted response based on behaviors, of a religious community. And there's a second question from Jackie Brilling about just limitations on the numbers of religious observational gatherings, particularly in given that we have upcoming holidays for many religions.
Yeah. So again, I mean, I don't mean to sort of beat the repeating drum, but I think what we're going to be looking at is, to the extent that any of these cases end up in a federal district court under the free exercise clause, we're going to be looking at that tension with respect to is this particular law oppressive, unreasonable, or arbitrary? So is it oppressive of one particular religion? And again, I think the facts matter. Then I think it could potentially be in constitutional hot water. But I think the facts in a large part are going to dictate that on the ground. But that's what the court's looked at when it's looked at public health measures historically, even in light of constitutional rights like freedom of assembly. So I see no reason why they would go in a different direction now. But the facts are going to matter in terms of whether there's ultimately, I think, a First Amendment violation there.
Thanks, Jared. There's a nice kind of concluding remark from Quincy Vale, a master's student from '95, who says, there simply must be some personal accountability. I think we would all agree with that. My right to swing my arm stops short of your chin. So on that concluding note, we could probably go for another half hour, 45 minutes with really thoughtful conversation and questions. We're trying to limit these to their hour so everybody can get back to their work and other endeavors. Once again, thank you to everybody, VLS hosts, as well as VLS alums, for joining us today. We will not be having a VLS alumni webinar in December due to the holidays, but we will continue our VLS webinar series in January of 2021. If you haven't done so already, you can mark on your calendars the upcoming VLS book club gathering on December 3rd. The book we are reading is a quick holiday read entitled Another Christmas Carol by Lee Woodard, class of 1982, JD, which is available on Amazon and available at other bookstores and through a link, I believe, to the author that was circulated to the VLS alums. The registration for this event is online now, so please visit the VLS website for all of the details. Thanks once again to Jared Carter. Thank you, VLS staff, and thanks especially to my fellow Swans for participating. We hope to see you at another virtual event soon. Thanks.
Thanks, everybody. Great conversation, great question.